It's if I forget. Before bringing the jurors in, on behalf of the defendant.
No, Your Honor.
Okay. Ladies and gentlemen in the gallery, okay, all trials are emotional. And trials such as this are even more so. You may see or hear things which you disagree with, which makes you upset, angry, or which you feel a need to respond. As difficult as that may be, okay, you can't do that in this courtroom. My concern is that you may do something that ultimately could influence one of the jurors. So that if you find yourself or see yourself getting emotional because of either something that's being said or something that you see, then you need to excuse yourself out of the courtroom. If I see someone doing something that I believe is in some way attempting to influence the jurors in some manner, okay, I will ask one of the deputies to have that person removed from the courtroom. One of the ways that we can ensure that both sides in this case have a fair trial is by making sure that there are no outside influences that in any way impair their ability first to be fair and impartial, but to be able to render a just verdict in this case. So I appreciate up to this point, at least all the folks that have been in the gallery have been very respectful for these proceedings. And I would hope that that would continue as we move throughout this trial. I've already previously indicated that unless the court has provided you permission to do so, okay, you cannot take photographs, you cannot take videos of these proceedings. If I find out that someone is sitting in here who has not received permission from the court doing so, I will have that person removed from the courtroom and they will not be allowed to return. So thank you, ladies and gentlemen. All right, Mrs. Harper. Okay. Type something again. Okay, we're good. going to ask the jurors if all of you would remain standing. Everyone else may be seated. If you would please raise your right hand. Do you swear or affirm that you will diligently inquire into and carefully deliberate all matters between the state of Ohio and the defendant, Adam Coy? Do you swear or affirm you would do this to the best of your skill and understanding without bias or prejudice, so help you God, or this you do, as you will answer under the pains and penalties of perjury? Please indicate by saying, I will.
I will.
You may be seated, ladies and gentlemen. All right, good morning, everyone.
Good morning.
All right, welcome to Courtroom 4B. Okay, in a moment we're going to have opening statements of counsel. Opening statements of counsel is information that will hopefully help you as you are listening to and considering the evidence. Opening statements are not evidence in this case. It's information that the attorneys anticipate, evidence that they anticipate you will see and hear throughout the trial. Before we start with opening statements of counsel, I do have some instructions that I'm going to read at this time. It's important, please, that you listen up while I do so. During the trial and after closing arguments of counsel, I will have a further opportunity to instruct you on matters of the law which you are to follow in this case. It is my duty to instruct you on the law, and it's your duty to follow the law as I will state it to you now, during the trial and at the conclusion of the evidence. First of all, it is your exclusive duty to decide all questions of fact that are submitted to you. In connection with this duty, you must determine the effect and value of the evidence, and you must not be influenced in your decision by any sympathy, prejudice, or passion toward any party, witness, or attorney. If in these instructions, or the instructions which I will give you at a later point in time, any principle or idea is repeated or stated in varying ways, no emphasis is intended, and none must be inferred by you. Therefore, you must not single out any particular point or individual sentence or instruction and ignore the others. Rather, you are to consider all of the instructions as a whole and to consider each instruction in relation to all the others. The fact that I give you some of the instructions now and some at the conclusion of the evidence has no significance as to their relative importance, nor the order in which I give you the instructions have any significance. The attorneys for the parties will have very active roles in the conduct of the trial. They have conducted the voir dire. They will make opening statements. They will question witnesses, make objections, and finally, they will argue the case as their last step before you hear my final instructions and commence your deliberations. I want you to remember, however, that the attorneys are not witnesses, and since it is your duty to decide the case solely on the evidence which you see or hear in this case, you must not consider as evidence any statement of any attorney made during the trial. If a question is asked by one attorney and an objection to the question is made by another attorney, the duty is placed by law upon the court to decide whether the objection should be sustained or overruled. If the objection is sustained, you will then not hear the answer to the question, and you must not speculate as to what the answer might have been or for the reason for the objection. In addition, if I sustain an objection to a question, you are to disregard the unanswered question. If a question is asked and the answer to the question is given before an objection is made, and if I sustain that objection, I am instructing you now that you are to completely disregard the question and the answer you have heard and not to consider any for any purposes whatsoever. I understand it is a difficult concept to disregard something that you have already heard, but it is an important concept for you to follow. If I overrule an objection, the witness will be permitted to answer the question, and you should not be concerned with the fact that an objection was made or as to the reason for my ruling. You are the judges of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witnesses. You will use the test of truthfulness, which you use in your daily lives. These tests include the appearance of each witness upon the stand, his or her manner of testifying, the reasonableness of the testimony, the opportunity he or she had to see, hear, and know the things concerning which he or she testified, his or her accuracy of memory, frankness or lack of it, intelligence, interest, and bias, if any, together with all the facts and circumstances surrounding the testimony. Use these tests and assign to each witness's testimony such weight as you think proper. You're not required to believe the testimony of any witness simply because he or she was under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your duty to determine what testimony to believe and what testimony not to believe. One witness, if believed by you, is sufficient to prove any disputed fact. Circumstances in any case may arouse sympathy for one party or the other. Sympathy is a common human emotion, and the law does not expect you to be free from such normal reactions. Again, you must decide the case solely on the evidence and the law before you, and must not be influenced by any personal likes or dislikes, opinions, prejudice, sympathy, or biases, including unconscious bias. Unconscious biases are stereotypes, attitudes, or preferences that people may consciously reject, but may be expressed without conscious awareness, control, or intention. Like conscious bias, unconscious bias too can affect how we evaluate information and make decisions. But please understand, ladies and gentlemen, the law and your oath as jurors, which you have just taken, require you to disregard sympathy, to disregard, anything that you would use negatively in evaluating the evidence. When you return to the court, well, when you came to the courtroom today, because this is your first time here for many of you in 4B, you noticed that there were notepads in the seats. Okay, the notepads have been provided to you if you wish to take notes. Okay, you're under no obligation whatsoever to take notes. Some jurors take notes because they believe that doing so helps them to recall the testimony. Other jurors do not take notes because they believe that it distracts from their ability to listen to the evidence. Whether you decide to take notes or not is your own personal preference. Now, the notepads are the property of the court. What that means is that anytime that we take a break, just leave the notepads in the seats and we will collect them at the appropriate time. When you go back to deliberate, okay, you will have your notepads with you. But please just remember, just because one juror took notes and another juror did not, that does not mean that the juror who took notes' memory was any better than the juror who did not take notes. At the conclusion of your deliberations, we will once again collect the notepads, rip out the pages, and have them shredded. Also, you see Mrs. Manahan sitting here taking down everything that's being said in the courtroom. Now, I don't want you to think that as the testimony is going on, and by chance you happen to miss something, daydreaming or whatever the reason may be, that you think, okay, well, that's not a big deal. When we go back to deliberate, I'll just ask the court to have that portion of the testimony read back. It's in the rarest of circumstances that I would have any portion of the testimony read back. it's extremely important that you listen to the testimony as it's being presented. As you recall, I had indicated to you previously that usually I like to go about an hour and a half or so, but it kind of just depends. It could be a little bit less, it could be a little bit more. However, at any point in time, if you need to take a break, please just get my attention. We will take a break. You don't need to tell me why. It's just, Judge, can we take a break? And we will take a break. All right. Does anyone have any questions at this time about anything that I have just said? All right. Thank you, ladies and gentlemen. Thank you again for your patience this morning. There were several legal issues that the attorneys and I did need to resolve before we could bring you here into the courtroom. At this time, we will have opening statements on behalf of counsel, so on behalf of the state.
Thank you, Your
Your Honor, counsel, ladies and gentlemen of the jury. December 22nd, 2020 was a cold night in Columbus, Ohio. That night, Andre Hill drove to 1062 Oberlin Drive in Franklin County, Columbus, Ohio, to meet with Destiny, a woman who he knew who lived at that address at 1062 Oberlin Drive. Andre drove a silver-colored SUV to Oberlin Drive. The SUV belonged to his boss. Andre had been using the vehicle to work a job while his boss was out of town. The SUV was what many would consider to be a work truck, a work vehicle that was filled with tools and equipment. When Andre Hill arrived at Oberlin Drive, he parked the vehicle on the street near 1054 Oberlin Drive and waited for Destiny to come out to meet him. Because it was cold, Andre was periodically turning the vehicle off and on to stay warm over a period of a couple of hours while he waited. The periodic stopping and starting of the vehicle engine attracted the attention of a neighbor. It attracted the attention of the resident at 1054 Oberlin Drive. His name is Robert Ronker. Mr. Ronker was disturbed by the noise, the stopping and starting of the engine. So he contacted police to report it and was advised that an officer would be out to check on the situation. Mr. Ronker made that call just before 1:30 in the morning on December 22nd, 2020. As a result of that call, Officer Adam Coy was dispatched to Oberlin Drive. Upon arrival, Officer Coy was initially investigating a vehicle that was parked in front of Mr. Ronker's residence at 1054 Oberlin Drive. However, Mr. Ronker noticed that Officer Coy was looking at the wrong vehicle. So Mr. Ronker came out, approached Officer Coy to advise him that the vehicle in question had actually moved up the street and was now parked along the side of the street at 1070 Oberlin Drive. Officer Coy then moved his cruiser closer to the location where that vehicle was parked. Andre Hill was inside that vehicle. Officer Coy had a brief conversation with Andre Hill while Andre Hill remained in the vehicle. During that conversation, Andre Hill advised Officer Coy that he was waiting for someone, and he showed Officer Coy a text message from his phone that said, "I'll be right out," or words to that effect. Officer Coy then told Andre Hill that was fine, and he returned to his cruiser to wait for Andre Hill to leave. Around that time, a second officer, Officer Amy Detweiler, arrived on the scene. Officer Detweiler and Officer Coy had a very, very brief exchange about the situation and determined that they needed to approach Andre Hill, who had actually just entered the garage of the residence at 1062 Oberlin Drive. That the residence where he was waiting on that person to come out. Now, here we have a photograph of that garage. At this point, Officer Coy and Officer Detweiler made their way up the driveway of 1062 Oberlin Drive towards the garage where Andre Hill was inside the garage. Officer Coy ordered Andre Hill to come out of the garage. Andre Hill began to comply with Officer Coy's orders and began to move towards the open garage door. He moved alongside a white car that was parked in that garage. Andre Hill had a cell phone in his left hand, which he had raised up towards the officers as if to show them something on the phone. His right hand was not visible. After Andre Hill rounded the bumper, the rear bumper of the white car, Officer Coy yelled "gun" and shot Andre Hill 4 times, killing him. The evidence will show that Andre Hill was not armed. He did not have a firearm. When the crime scene was processed, BCI agent Asia Chung recovered items at the scene, including a cell phone, including keys in the area where Andre Hill was shot, but there was no firearm. You will hear from a number of witnesses in this case, among them Officer Detweiler, the second officer who was there. You'll have the opportunity to view body-worn camera of Officer Detweiler, as well as body-worn camera of Officer Coy. Keep in mind, as you're viewing this, that the officer's body-worn camera was not on during their initial approach. So there are some portions of the events that were either not captured on video or that were captured without sound due to a feature on the body-worn camera that records the 60 seconds of video prior to the body cam being turned on, but records it without sound. In addition to viewing the body-worn camera, you'll also hear from Robert Ronker, the 911 caller, as well as other witnesses. Adam Coy has been indicted for 3 crimes. Those crimes include the crime for killing Andre Hill, a crime for felonious assault, and crime for reckless homicide. Let's run through what each of those entail. The first one, causing the death of Andre Hill. The state of Ohio has to prove beyond a reasonable doubt all the elements of these 3 offenses. What does the state of Ohio expect to prove? That the defendant, Adam Coy, caused the death of Andre Hill as a proximate result of committing or attempting to commit felonious assault, which is an offense of violence of the 1st or 2nd degree. That's the first offense. Now, as part of that, the state has to prove that the defendant, Adam Coy, acted knowingly in causing the death of Andre Hill. What is knowingly? A person acts knowingly regardless of purpose when the person is aware that his conduct will probably be of a certain nature or a certain result. A person has knowledge of circumstances when he is aware such circumstances probably exist. Because you cannot look into the mind of another, knowledge is determined from all of the facts and circumstances in evidence. This is that mental element that the state will have to prove. The second crime, which the state has to prove beyond a reasonable doubt was committed by Adam Coy, is felonious assault. What's felonious assault? What does the state have to prove? The state expects to prove that the defendant, Adam Coy, knowingly caused serious physical harm to Andre Hill, or alternatively, that Adam Coy caused or attempted to cause physical harm to Andre Hill by means of a deadly weapon. That's the second offense. The third offense is reckless homicide. The state has to prove beyond a reasonable doubt that the defendant, Adam Coy, recklessly caused the death of Andre Hill. And here we have a definition of recklessly, that mental element that we've been talking about. In order to prove recklessly, the state has to show a person acts recklessly when, with heedless indifference to the consequences, that person disregards a substantial and unjustifiable risk, that that person's conduct is likely to cause a certain result or be of a certain nature. A person is reckless when, with heedless indifference to the consequences, that person disregards a substantial and unjustifiable risk that such circumstances are likely to exist. The state of Ohio expects that at the end of this case, it will have proven to you beyond a reasonable doubt that the defendant, Adam Coy, is guilty of all three of those crimes. Now, the state also expects that the defense will assert that Adam Coy's use of deadly force against Andre Hill was reasonable and lawful in his official capacity as a police officer, and thus the state expects he will submit that he was justified in his actions. The defense will have an opportunity to present evidence to establish that defense called justification. In order to establish justification, the defendant, Adam Coy, has to prove that he was justified in using deadly force by a preponderance of the evidence. The state then has an opportunity to refute Officer Coy's use of deadly force was reasonable or justified. In order to do that, the state expects to call an expert witness, Seth Stoughton, to testify regarding national police practices, and the state expects that that expert will opine that Adam Coy did not act within those practices. Let's run through the justification, defense, and reasonableness. The standard for determining whether or not the use of deadly force by a police officer is justified is a reasonableness standard. If the officer reasonably believes deadly force is necessary to defend himself from the actual use of force or from the imminent use of physical force by a suspect that poses a threat of death or serious physical harm to the officer or others, then the officer's use of deadly force is not unreasonable. Keep in mind, reasonableness requires careful attention to the facts and circumstances. The reasonableness standard of a particular use of force must be judged by the perspective of a reasonable officer on the scene, not with the 20/20 vision of hindsight. The standard of proof for proving that justification defense is a preponderance of the evidence. That's the slightly more than 50% standard that you've heard about in voir dire. So in order to prove that he was justified in using deadly force, the defendant, Adam Coy, must prove that he was justified by a preponderance of the evidence. The preponderance of the evidence is the greater weight of evidence. It is evidence that you, as jurors, believe because it outweighs the evidence that is opposed to it. A preponderance means evidence that is more probable, more persuasive, or of greater probative value. It is the quality of the evidence that must be weighed. If the weight of the evidence is equally balanced, or if you as jurors are unable to determine which side of the issue has proven the preponderance, then the defendant, Adam Coy, has not established the defense of justification. The defendant, Adam Coy, may call his own expert witness to give an opinion about the events that occurred that night on December 22nd, 2020. And that expert may give an opinion as to whether or not Officer Coy's actions were justified. In addition to the opinions of any defense experts, you may also hear evidence related to Adam Coy's version of events that took place that night. The state of Ohio asks you to listen carefully to that information, to critically examine and analyze all of that information. This is something that you'll likely circle back to at a later point. Ultimately, ladies and gentlemen, the determination as to what happened that night and whether Officer Adam Coy's actions were reasonable or justified will be up to you. At the end of this case, the state of Ohio will ask you to find that Officer Coy's use of force was not reasonable, that Andre Hill followed the commands of Officer Coy, that Andre Hill was not a threat to Officer Coy or Officer Detweiler, that Andre Hill did not have a weapon, that Officer Coy's actions were not reasonable under the circumstances, and that Officer Coy was not justified in shooting and killing Andre Hill. At the end of this case, the state of Ohio will ask you to find Officer Adam Coy guilty of all three of the offenses with which he has been charged. Thank you.
Thank you, Ms. Hamlin. All right, on behalf of the defendant.
Thank you, Your Honor. May I proceed?
You may.
May it please the court, Mr. Collins, Mr. Coy, Mr. Pearson, and Ms. Amlin. Good morning, ladies and gentlemen. The state of Ohio just told you that Adam Coy did not perceive a threat on December 22nd, 2020. The state's own witnesses will tell you that the fact that there was no weapon found on the scene does not matter, contradicting the state's theory. You are going to hear that officers do not have to wait until they see the glint of steel. That what matters is how the hand was being presented, because an action is faster than a reaction. The state's own witnesses are going to tell you that. You are going to hear that that is how officers are trained. You are going to hear from the state's own witnesses that actual possession of a weapon is irrelevant, that police officers are allowed to be mistaken. Whether you agree with that or disagree with that, that is what their training says. You are going to hear from the state's own witnesses that Adam Coy does not have to await the glint of steel in order to use deadly force. Now, you will hear that Adam Coy saw that glint of steel, make no mistake. He saw a glint of steel. He saw metal come up in a hand. And the state's own witnesses will tell you that police officers do not have to wait. They don't have to be 100% certain that that glint of steel that's coming at them is in fact a firearm. So we ask that you keep that in mind as you hold the state of Ohio to their burden and examine the credibility of the state of Ohio's case. You are going to hear that on December 22nd, 2020, my client believed he was going to get shot. He yells, "Gun, gun," steps off the line, draws his weapon, and fires at what he honestly believed was a revolver being leveled at his direction. You are going to hear that he was mistaken, that it was not a revolver, but instead, that glint of steel turned out to be a metal mass of keys. You are going to hear that police officers are allowed to be mistaken, and you are going to hear, ladies and gentlemen, that even though there was no weapon found, his action to respond with deadly force was consistent with national police procedures. And that is what the evidence will show. Now, opening statements. Just as the judge indicated, they're an opportunity for each side to lead you down a path of what each side believes the evidence will show. Or is, as the case here, it's an opportunity for me to lead you down a path of what we believe the evidence will not show. For instance, the state of Ohio just tried to tell you that our client was reckless when he made the split-second decision to use deadly force. However, ladies and gentlemen, the evidence will show that our client was not reckless. He did what he was trained to do. And what he was trained to do was shoot to stop the threat. The evidence will show he didn't act with heedless indifference. He didn't empty his clip. He was a trained officer doing what he was trained to do, to stop the hand with what he believed was a revolver being leveled at his direction. Now, every time Mr. Collins and I prepare for a case, we like to look for what we call a theme. And what I mean by theme, ladies and gentlemen, is when you have a case and examine a case, you have witnesses, some civilian, some professional. You've got some evidence, some physical, some circumstantial, and those all sit on the periphery of a case. But the theme, ladies and gentlemen, is what's at the core fundamental concept of a case. And so the theme of this case, the core fundamental concept, is one of justification. And that was because the mistake that Adam Coy made on December 22nd, 2020 was reasonable because he was acting in accordance with his training. Now that is because the evidence will show that on December 22nd, 2020, Adam Coy was justified when he made the decision to use deadly force. Because number one, he had a subjective belief that he was in immediate fear of great bodily harm or death. And number two, that belief was objectively reasonable based on the totality of the circumstances when viewed through the eyes of a reasonable police officer on the scene without the benefit of 20/20 hindsight. And that's because, ladies and gentlemen, the evidence will show that Adam Coy saw the glint of steel being leveled at his direction, believed it to be a gun. He was mistaken, and the evidence will show that that mistake was reasonable. And we will prove that, ladies and gentlemen, by a preponderance of the evidence, or more likely than not. And as the judge will tell you, if you find that we have met our burden of proof of more likely than not, if we have proven justification to you, more likely than not, then that serves as a complete defense to all three charges. Now, with the benefit of hindsight, nobody in this courtroom disputes that December 22nd, 2020, the events that occurred were tragic. And it's not lost on us that someone lost a life. Someone lost a father and a friend. However, as the judge told you and will continue to remind you, that when you examine a case, when you analyze and when you decide a case, you must not consider sympathy or empathy. And it is a tough task, ladies and gentlemen, because undoubtedly the state of Ohio is going to try to use that we are all humans in this courtroom. I am warning you now that it's not easy, and it doesn't get any easier the more times you see a body-worn camera or the more times you see a gruesome photo. I am sure they will play the body-worn camera over and over and over again. They will slow it down for you, go frame by frame for you. They're going to show you graphic photos. They're hard to see. It's hard to hear. And it's hard because we ask you to be almost clinical in your analysis. But that's what the law requires. Again, whether you agree with it or disagree with it, that is what the judge has already told you, and I promise you, he will tell you again. And so every time the state plays that video, or you see that picture, you see that body-worn camera go frame by frame, Mr. Collins and I would ask that you keep in mind that admonition that the judge gave you, that as you took an oath as a juror, you are not to consider sympathy or empathy when deciding this case. Now, unlike the majority of the cases that we try in our criminal justice system, we have a burden here. However, that does not alleviate the state of Ohio from meeting its burden. It is they that must prove to you, beyond a reasonable doubt, each and every element of all three crimes charged. Beyond a reasonable doubt is our highest legal burden in our system. As the judge will tell you, it's proof of such nature you would rely upon it in your most important of your own affairs: care for an elderly parent, surgery for a child. And if they fail to prove all of those elements to you beyond a reasonable doubt, the judge will tell you your analysis stops there. Now, you're going to hear two competing theories that the state is pursuing against our client. One is saying that he shot to injure Mr. Hill, that he knowingly committed a felonious assault, which proximately resulted in the death. The evidence will show that he's not trained to shoot to injure. He's not trained to shoot to kill, but rather the evidence will show that he is trained to stop the threat of what he believed to be a revolver. The second theory is that he did not act knowingly, but rather he acted recklessly, with heedless indifference concerning the consequences of his actions. Again, ladies and gentlemen, the evidence will show that Adam Coy did what he was trained to do on December 22nd, 2020. Not shoot with heedless indifference, but trained to shoot to stop the threat. The evidence will show they are not going to meet their burden of proof, because the evidence will show, ladies and gentlemen, that the state started from a premise and worked backwards. The state will not be able to prove any of the mental elements beyond a reasonable doubt because of those conflicting theories. The state's own witnesses will support the defense of justification. And the expert that the state is going to call, a man by the name of Seth Stoughton, he comes to multiple conclusions. Listen to those conclusions, ladies and gentlemen. One is contradictory to what the judge is going to tell you. And a separate conclusion is the same exact conclusion that the defense experts come to. And that is that he will tell you, if an officer believes a gun to be pointed at him, then that officer is justified in shooting. So that is why the state of Ohio will not be able to meet its burden. And again, if that is the case, the judge will tell you your analysis stops. But even if you find that somehow, despite what I've just told you, that the state of Ohio does in fact meet its burden, then and only then do you analyze the defense of justification. May I have the Elmo judge? And so this is the flow chart of how your analysis will go. First, you will analyze, did the state meet its burden of proof beyond a reasonable doubt? If no, your analysis stops there, and your verdict is not guilty. If yes, then you must analyze the defense of justification. You must ask yourselves, did the defense prove justification by a preponderance of the evidence, or more likely than not? If yes, then your verdict will be not guilty, and if no, then your verdict will be guilty. Thank you, Your Honor. And so I want to talk about our burden, ladies and gentlemen. It's different than the state of Ohio's. Certainly not as high as the state of Ohio's. But we welcome that burden, ladies and gentlemen. We have to prove to you that our client was justified by a preponderance of the evidence. As the judge will tell you, a smidge over 50%, or more likely than not. So as you listen to the testimony and the defense that we put on, remember, we have to prove two prongs to you by preponderance of the evidence. Number one, the subjective component, that it is more likely than not that Adam Coy had a belief that he was in imminent fear of great bodily harm or death. And number two, the objective component, that it is more likely than not that his decision to use deadly force was reasonable, given the totality of the circumstances in the eyes of a reasonable police officer on the scene, going through everything my client did on December 22nd, 2020. Now, this is where the mistake comes into play, ladies and gentlemen. In that calculus of reasonable, we have to prove that the mistake Adam made was more likely than not reasonable, given the totality of the circumstances. Again, we have to prove that by a preponderance. So I'm asking that you keep those two components of justification in the back of your mind as you are listening to the testimony here. Is it more likely than not than when Adam saw what he believed to be a gun? Is it more likely than not that he was in fear for his life? And number two, is it more likely than not reasonable that he made a mistake when he saw the steel, the metal that resembled a gun in both size and color? Now, your task is not an easy one, and the judge is going to instruct you that you must analyze that second component from the eyes of a reasonable police officer on the scene. You must examine the totality of the circumstances, and the judge will tell you, can't use hindsight in your analysis. The judge will tell you, you must account for the fact that police officers are often forced to make split-second decisions in circumstances that are tense, uncertain, and rapidly evolving about the amount of force necessary in a particular situation. And there's a reason why the law of justification, ladies and gentlemen, is written in this fashion. And that's because unlike judges, unlike juries, unlike me, officers on the beat are not afforded the luxury of armchair reflection. Every single day, our men and our women on our police force put on their uniform, not knowing if they're going to return to their home or their armchairs for doing their job. And the court will tell you that you have to take that into account, that they're required to do their job. Now, let me tell you a little bit about Adam Coy. 2 days after high school graduation, he joined the Army, was honorably discharged for fighting our country and earned a rank of Sergeant E5. He returned from the Army and immediately began his career in law enforcement. He's got 3 kids and a wife, and on December 22nd, 2020, he faced every law enforcement officer's nightmare. You are going to hear that on December 22nd, 2020, a little after 1:30 a.m., Adam was in the area of Ackerman and Olentangy when he was dispatched on a call for service to Oberlin Drive, 1054 Oberlin Drive. That was the first house that you guys went to on your jury view. He was dispatched on a 4848A, suspicious car, suspicious person report, because there was an SUV that had been turning off and on for some time. Adam arrived to 1054 Oberlin and approached that SUV that was in front of that address. The caller met Adam outside and told him, hold on, that's the wrong SUV. The SUV that was in front of my house had since moved, not to 1062, but to the third house that you guys went to, past 1062, down to 1070 Oberlin Drive. That SUV was in fact in front of 1054, but that suspicious vehicle had moved to 1070. So Adam pulls his cruiser behind the SUV and exited the cruiser as he was trained to do. He pulls offset, meaning he pulls up behind the car, but not directly behind, a little bit offset, as he was trained to do. As he approaches the driver's side of the SUV, the driver rolls down his window, makes an X with his arms, with a cell phone in his right hand. He leans over as if he was hiding something. Before Adam can get a word out, he was shown this phone. And based on those actions, it was Adam's understanding that somebody was going to come outside, that he was waiting for someone. So based on these actions, the call, the fact that a suspicious person was sitting in a suspicious vehicle, that he appeared to be hiding something, that he was dismissive, that he seemed like he didn't want to speak to Adam Coy, that he appeared wide-eyed and jittery, Adam decided to watch, to make sure that what his understanding was, that this person was waiting for somebody, that was in fact the case. So he returns to his cruiser and he waits in the area. He wants to see, is a person gonna come out to the car, or is this person just going to leave? He's waiting for that. Now, what Miss Amlin didn't tell you, ladies and gentlemen, is that Adam gets back to his Columbus police cruiser. He opens the door. He sits in the cruiser with the door open, as he was trained to do. And after about 1 minute, the person in the vehicle opens the door of the SUV. He exits the SUV. As this is happening, Adam gets out of the driver's seat of his cruiser, stood next to his cruiser to observe what was going on. The person walks behind the SUV directly in front of Adam's cruiser, and he didn't go to the house that he was parked in front of. He didn't go up to 1070 Oberlin Drive. Instead, he went up to 1062 Oberlin Drive, and he pounded on the door. Nobody comes downstairs. Nobody turns on any lights. He waits and waits, just less than a minute, and then proceeds to pound hard on the front door again. Again, all while Adam is observing. There's still no movement in the house, and it has remained dark. The person who is pounding on the door walks back to his SUV, opens the driver's side door, leans in and is rummaging through some things as if he were looking for something. He then walks back toward 1062 again. And Adam asks, "Hey, what's going on?" And the person ignores him. Adam watches the person continue to ignore him, and as he's doing so, he keeps looking back to see what Adam is doing, seeing what Adam's response was. In the meantime, that is when Amy Detweiler pulls up. The state didn't want you to hear all of that in between, though. That is when Amy Detweiler pulls up, because she was dispatched too on the original suspicious person or suspicious call. The caller at 1054 comes back outside, and Adam yells at him to go back inside for his own safety. Officer Detweiler exits her cruiser, and she and Officer Coy briefly communicate about something not being right, not knowing what is going on with the person they were sent to investigate. In the meantime, Adam and Amy lose track of where the person went. He disappeared. It is pitch black, ladies and gentlemen, at 1 a.m. You had the benefit of going to the scene in the daylight. However, in the eyes of Adam Coy and Officer Amy Detweiler, it was pitch black that night. So, Officer Detweiler and Officer Coy do what they're trained to do. They begin to look for the person to investigate what is going on. It was pitch black in the dead cold of winter, and at this point, nothing is adding up to Adam, and he lost sight of him. At this point, he has a duty to go forward at this point. And he will tell you, I didn't know what was going on. I thought maybe it could have been a burglary or something to that effect. But at this point, I had to go investigate because I had what's called reasonable articulable suspicion to potentially believe a crime was being committed or was about to be committed. Adam Coy approaches the pine tree that you saw located between 1062 and 1070 Oberlin. The garage door was open. Something again that is not normal at 1:30 or 2 o'clock in the morning in the middle of the winter during the holiday season. There's no light in the garage. Adam sees a white car parked. He has his flashlight and he's scanning the area around the house. Initially, he doesn't see anybody in the garage. Then he sees a glow from a cell phone. He flashes his flashlight in that direction and sees the same suspicious individual that was in the car that ignored his commands huddled in the garage. Amy Detweiler has a different view. She pursues up the driveway and is to the right of Adam. As Adam is walking up the drive, he says, "Show yourself, come out here, something's not adding up." The person turns his body with his shoulder partially bladed and begins walking toward Adam and Amy with his eyes fixed on Adam. The person has a cell phone in his left hand, raising about shoulder level. Adam will tell you that training dictates that he perceived that to mean he was being distracted, that was to serve as a distraction, because neither Adam nor Officer Detweiler could see the right hand. As he's approaching and as he clears the bumper of his vehicle, you will hear that Adam Coy believed a hand to be raising up, sees the metal glint of steel, yells, "Gun, gun," steps offline, and fires 4 times until he sees that threat stop and he sees that threat drop. He immediately hits his body-worn camera. Columbus Police body-worn cameras at the time only had a 60-second look-back period. So you're going to see that body-worn camera did, in fact, capture the shooting. The video does not have audio at the time of the shooting, but you are going to see how quickly this all happened, how quick Adam was forced to make that split-second decision. Now, he doesn't let Officer Detweiler go right up to the person because he believes that person still had a gun. Once safe to approach, Adam does so, and he doesn't see a gun. But instead, he sees a mass of silver keys on a key with a key fob. You will see this metal mass of keys, ladies and gentlemen. He realized he was mistaken about the massive keys being a revolver. He was in total shock, and he became physically ill. The evidence will show, ladies and gentlemen, that based on that account of events that I just told you, that we will have met our burden. Number one, that Adam had a subjective belief, that it was more likely than not that when Adam believed he saw a firearm in that hand, that he was more likely than not afraid for his life. And number two, that he was objectively reasonable, that his action to use deadly force was objectively reasonable based on the totality of the circumstances. His actions were reasonable because he acted in accordance with his training when viewed from the eyes of a reasonable police officer on the scene without the benefit of 20/20 hindsight. And even though that he was mistaken, the evidence will show that mistake was reasonable because the keys were both similar in size and color to that of a revolver. Now, Amy Detweiler, the state's own witness, is going to provide you corroboration of the defense of justification. She's going to provide you corroboration that Adam yelled, "Gun, gun," before firing. She's going to provide you corroboration that he does not let her approach immediately after because he still believed that a weapon was within reach. Now, the second prong of justification I want to focus on for a moment. How are you going to know what a reasonable police officer, how that person would have acted? How are you going to know about these national police standards that the state and I keep talking about? You're going to hear from 2 defense experts, decorated law enforcement officers with more years of law enforcement experience than I have on this earth. Between the 2 of them, they have trained thousands of law enforcement officers all over the world on deadly force. Particularly, they've trained officers in this city and in this state. Their names are Kevin Davis and Jim Scanlon, both certified trained police officers here in the state of Ohio and now retired. Kevin Davis has been in law enforcement for almost 40 years, and he's a certified force analyst. Jim Scanlon was a law enforcement officer for 33 years, 19 of which he served on SWAT. He started his own company in 1999, where he consults and trains officers with officers involved in shootings, firearms, hostage barricade situations, and critical incident training. Listen to the two defense experts and compare them to the state of Ohio's expert. The evidence will show that the state's expert does not hold a candle to the defense experts when it comes to qualifications. Now, Jim Scanlon and Kevin Davis use different methodologies in analyzing this use of force, but they are going to come to the same conclusion. They are going to tell you why and how Adam acted accordance with national training and police procedures. They're going to help you analyze what a reasonable police officer would do. Listen, as one of our experts will tell you, why Hill's actions dictated what Adam did next. Then, after standing in Adam's Coy's shoes, experience what he experienced, as our expert will tell you, listen as they will tell you it required immediate action on behalf of my client. One of our experts are going to walk you through some factors. These factors will be mentioned in the jury instructions that the judge will give you. Keep these factors in the back of your mind as our expert talks to you about them. Number one, the severity of the crime at issue. Listen as our expert will tell you that Adam Coy had a lawful objective for taking action. He had a duty to go forward. He will tell you that there is no more severe there is no more severe threat than thinking that a gun is being pointed at you as a police officer. The second factor, whether the person posed an immediate threat. Listen, as our expert will tell you, that officers are trained that the actual possession of a gun is irrelevant, that what matters is the perceived threat based on how the object in the hand was presented. There is no question, as the evidence will show, that based on training, when a perceived threat is a person with a gun, that they are an immediate threat. Evidence will show that Coy's decision to use deadly force when examining this factor is more likely than not reasonable. And the third factor that you will hear these experts discuss is whether the suspect was actively resisting or attempting to evade arrest. You're going to hear that the person was non-responsive, that he disappeared, that he ignored Coy. And so evidence will show that when you analyze this factor, it is more likely than not reasonable with his use of deadly force. You are going to hear, ladies and gentlemen, how officers are trained, what they are trained to believe as if it is second nature. You're going to hear about threat patterns that officers have to train to indicate, recognize, process, and respond to these threat patterns. You're going to hear that they are trained to know that an action is always faster than a reaction. You are going to hear from experienced, trained law enforcement officers that when a hand comes up, an officer does not need to be sure that there is a firearm in that hand before responding with deadly force. You are going to hear that Adam Coy waited until he saw that glint of steel come up in his hand. You are going to hear from experienced, trained law enforcement officers that an officer is allowed to be mistaken. And you are going to hear from experienced, trained law enforcement officers that a perceived threat is enough. You are going to hear and you are going to see why that mistake is more likely than not reasonable. In the dark, based on the totality of the circumstances. You're going to hear about the limitations of seeing in the dark. You're going to hear about the limitations of what the body-worn camera captures. You're going to hear time and time again that the camera does not capture everything that our eyes do. and you're going to hear and see everything that camera captured versus what Adam Coy perceived on that night. Now, the state's expert, Seth Stoughton, I think he was a police officer for maybe 4 years and 7 months. He's got no experience here as a law enforcement officer in the state of Ohio, and certainly not in the area where the shooting took place. But even he, a much less experienced officer, will tell you that if an officer believes a gun is being leveled at him or her, they are allowed to shoot. Even he will tell you that you need not wait the glint of steel. Even he will tell you an action is faster than a reaction. And even he will tell you officers are allowed to make mistakes. In recap, ladies and gentlemen, the state of Ohio has the burden of proof here. They have to prove to you each and every element beyond a reasonable doubt. If they do that, only then do you get to our defense of justification. Our defense of justification is more likely than not. And as the evidence will show, at the end of the trial, the evidence will show that it is more likely than not that Adam Coy believed he was about to be shot because he believed that that person had a firearm in his hand. And the evidence will show that based on the totality of the circumstances, in the eyes of a reasonable police officer on the scene, experiencing what Adam Coy experienced on that day without the benefit of 20/20 hindsight, the evidence will show, ladies and gentlemen, that that decision to use deadly force was more likely than not reasonable because he acted in accordance with his training, as he was trained to do. As such, at the end of trial, my partner, Mr. Collins, will come before you and ask that you find Adam Coy not guilty of all 3 charges. And that's because he was justified when he took those actions on December 22nd, 2020. I thank you for your time.
Thank you, Ms. Stevens. Counsel, please approach. Off the record. Okay, ladies and gentlemen, we're going to take about a 10-minute break. If I could get you back in the jury room at about 1:15. Remember the admonitions that I've given you with respect to discussing this case among yourselves or with anyone else. All rise for the jury. See everyone back in about 10 minutes. You may be seated, everyone. May be seated. All right. Okay, council, at this time, we're going to go ahead and break for lunch. If I can get everyone back here before 1 a.m., 1 p.m. Actually, 1 a.m. may not be that bad. But yeah, get everyone back here before 1 p.m. Get started as close to that time as we can. All right. Thank you, everyone. We're adjourned for lunch.